Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. Our topic today is an update on the CFPB's Small Business Data Collection Rule. My name is Tori Shinohara, and I'm a partner in Mayor Brown's Financial Services Regulatory Enforcement Practice in our Washington, D.C. office. I'm joined by my partner, Frank Doorley, who's also a partner in our Washington, D.C. office. Also joining us today is special guest Kate Rock. Kate is a partner with Guidehouse and focuses her practice on banking, insurance, and capital markets. Kate, thanks for joining us today.
Thank you for having me.
So there's a lot that's been going on related to the status of the 1071 rule, including a recent preliminary injunction by a Texas court and some other cases that are percolating out there. So just to kind of level set for our listeners, Frank, can you bring everyone up to speed on the status of the rule and the recent court decisions?
Yeah, great question. So shortly after the final rule was issued, Rio Bank and the Texas Bankers Association filed a lawsuit in the U.S. District Court for the Southern District of Texas, alleging that the 1071 rule was invalid because it was issued using funds that were unconstitutionally appropriated to the CFPB pursuant to the Fifth Circuit's ruling in the Community Financial Services Association case, or CFSA for short, which held that the CFPB's funding mechanism violates the Constitution. The CFSA case, of course, is binding on the federal district courts in Texas. The plaintiffs also alleged that portions of the 1071 rule violated the Administrative Procedure Act. The plaintiffs asked for a nationwide injunction staying the rule's implementation, which the CFPB opposed. The CFPB's motion in opposition argued that the plaintiffs lacked standing to challenge the rule, but also argued that even if an injunction were to be granted, it should be narrowly tailored and only applied to the plaintiffs who were actually before the court, and that any injunction should be crafted so that it terminates automatically if the Supreme Court were to reverse the Fifth Circuit in the CFSA case and hold that the CFPB's funding structure is constitutional. The court issued its ruling on the motion for the injunction on July 31st of this year. First, it found that Rio Bank did have standing, so the court proceeded to the injunction. And on the injunction, it found that an injunction was appropriate pending the outcome of the CFSA case, but it also gave the CFPB somewhat of a win. The court denied the plaintiff's motion for a nationwide injunction, and it limited the scope of the injunction to the parties before the court. So that injunction issued by the court only applies to Rio Bank or to banks that either are members of the ABA or the Texas Bankers Association. The court stayed the rule as applied to those plaintiffs pending the Supreme Court reversing the Fifth Circuit in the CFSA case. And in the event that the Supreme Court holds that the CFPB's funding structure is constitutional, the court directed the CFPB to extend the deadline for the plaintiffs to come into compliance with the 1071 rule to account for the period that implementation of the rule is stayed for the bank plaintiffs. Separate and apart from the Texas litigation, the Kentucky Bankers Association and a group of Kentucky banks also filed their own lawsuit against the CFPB in Kentucky federal court. The Kentucky plaintiffs advanced similar arguments to the Texas plaintiffs. The Kentucky banks claimed that the CFPB's funding structure is unconstitutional, and because the Bureau issued the final rule with funds derived from unconstitutional sources, the 1071 rule itself violates the Constitution. On September 14th, the Kentucky court granted the bank's motion for a preliminary injunction and enjoined the CFPB from enforcing the 1071 rule until the Supreme Court issues an opinion that the CFPB's funding structure is constitutional. Now, the courts issuing these injunctions raises just as many questions as it answers. The first question is, what happens to the 1071 rule now? And what do financial institutions who aren't parties to these injunctions do? Because now you have this status quo where the rule is stayed for some financial institutions, but not for others, which doesn't really seem to be sustainable. And it might be resolved before too much longer because additional trade associations and financial institutions are moving to intervene in the litigation and file their own motions for injunctions. So, for example, a group of credit unions moved to intervene in the Texas litigation in August, and the court granted the credit union's motion. This was followed shortly thereafter by the credit unions filing their own motion for a preliminary injunction. And since then, the Equipment Leasing and Finance Association, along with a motor vehicle floor plan lender, have also intervened in the Texas litigation and moved for their own preliminary injunction. The same legal analysis that the court relied on to grant the injunction for the original plaintiffs should also apply to the subsequent interveners. So it raises the question of whether the courts will keep extending these injunctions to additional parties, or if the CFPB will drop its opposition to the nationwide injunction pending the outcome of the CFSA case. Last month, a consortium of trade associations sent a letter to Director Chopra arguing that the status quo is unsustainable in light of the Texas injunction. The groups noted that we now have one set of implementation dates for many financial institutions, while some other financial institutions have an entirely different set of effective dates and implementation dates just because of their participation in a lawsuit. In the trade's view, this status quo results in disparate treatment of financial institutions and leads to the law being enforced inconsistently, which, in their view, is contrary to the objectives of the CFPB. The trade's letter requested that the CFPB ensure parity and consistency across financial institutions and pause the 1071 rule's effective date and compliance dates until the CFSA matter is resolved by the Supreme Court. Their argument may have just become a lot stronger in the last week now that the court hearing the Kentucky case also issued its own injunction. And Kate, what are you hearing from the industry on this?
Sure. Thank you, Frank. And I agree this is a great place for us to start today, as it's always top of mind and in the conversations we're also having. But while I'd say it appears to give relief to many financial institutions, without knowing the full timeline impacts and having all the questions you just raised, Frank, answered, financial institutions should continue to move forward as if the existing timelines are still in place. And I would say that is consistent with what we are seeing. So the clients that we have been working with and talking to even before the rule was finalized, they are continuing forward, even though for those who are impacted by this, they might have a little bit longer than initially anticipated. And so while potentially it is anticipated that the compliance date will move out a certain time period, and we have been hearing time frames such as 8 to 9 months. Again, financial institutions really should not sit back and watch. I think many are viewing it as an extension of the current 18-month implementation timeline for those who need to work to get into compliance with the October of 24 date. And I think many of us know that was a key area of focus for the industry and asking for more time to get ready to get into compliance with the rule. So this may provide those who are impacted with that extra time. So again, bottom line, I think continue to move forward and work to get into compliance with the rule until you have more information on what these rulings and injunctions mean.
Yeah, those are great points, Kate. And one thing I think is important to remember is that the CFPB has a statutory obligation under the Dodd-Frank Act to issue the 1071 rules. And in fact, some of us might remember the CFPB was actually sued by some advocacy groups over its failure to issue the rules in the first place. So there has to be some 1071 rule, but what happens if the Supreme Court upholds the Fifth Circuit in the CFSA case? Does that mean that the CFPB has to go back to the drawing board on the rule and try again, or Does Congress have to amend the Dodd-Frank Act to create a funding mechanism that passes constitutional muster, and then the current rule will go into effect? And I think we're going to have to wait until we see how the CFSA case shakes out before the Supreme Court to answer some of those questions. But Kate, I agree with you in the meantime that financial institutions should continue to work towards the implementation date and keep the ball rolling. And Kate, one more question for you. Now that we're close to 6 months since the final rule was published, can you tell us what financial institutions should be thinking about now and where they should be in their journey to implement the 1071 rule?
Sure, Frank, and I think we could probably discuss many different topics under this question, but maybe I'll focus on two for today. I think first, getting an understanding of the CFPB's view on enforcement, where they might focus, and managing risk, and did think it would make sense for us to spend some time talking about specifically discouragement risk today, given that was a new item within the final rule and one that has been part of many conversations that I have been having. And then the second point maybe to talk through some would be that organizations should make sure they have an understanding of their current application and intake processes, really conduct that current state assessment, understand what is being done now. That is important, as it's hard to change a process without understanding where you are starting from and then adding on those additional requirements that you need to work to get into compliance with the new 1071 rule. So going back to the CFPB's enforcement and managing risk, I think one of the things that stands out is the peer benchmarking that is planned to occur by the CFPB. And they plan to use that as a mechanism to understand if a financial institution is effectively managing both discouraging customers from answering demographic questions, as well as over-encouraging customers to respond. And I think this is a topic that's getting attention because there is limited information out there now to benchmark against. And this peer information will not be there for a long period of time. So how can organizations get ahead of this or start thinking through it? One thing that we are aware of is that the CFPB is looking to engage financial institutions and industry experts as they are also starting to prepare themselves for this new rule. And so I know some of our clients are thinking through, does it make sense to express their views on peer groups, help shape potentially how the CFPB views and defines peers, because this will be challenging considering the many different organizational types that are impacted by the rule. And is a bank going to be compared to a fintech, for example, and what might the implications of that be? Before I move on to a little bit more around discouragement risk, I guess a question to you, Frank or Tori, is there any insight from your perspective? I know there was a little bit in the final rule, but what the CFPB will be thinking about in terms of peer groups that you're aware of, or any additional information on whether or not they may or may not use proxy data here.
Yeah, that's a great question, Kate. I think that perhaps the CFPB has not yet fully crystallized its views in terms of peer benchmarking because they obviously, as you pointed out, don't yet have the data. I think a lot of the first few years is going to be making sure the data is good, making sure there's data integrity. But I think that if you look at other areas where the CFPB has looked at peer comparisons, and specifically under the Home Mortgage Disclosure Act and things like market penetration and redlining risk, I could see them looking at peers based on things like industry. I could see them looking at peers based on things like lender size or geographic market. I think there's a lot of ways that they are going to be able to slice and dice the data. And I think that also is going to provide opportunities for institutions to slice and dice their own data and try and identify what they believe is their correct peer group for comparison purposes.
That's great. Thank you, Tori. I guess just continuing on the topic of discouragement risk here. I think one of the other key things that organizations could be thinking about is really starting early, starting to create that awareness internally, have conversations, establish the working groups, educate your employees. And I think many are realizing that some of the conversations that their employees are going to have may ultimately be challenging conversations as they work to begin to collect this optional demographic information. So starting that process early and ensuring you have that proper training in place, all things to be thinking about now. The other thing I'd say is establish monitoring or analytics, kind of that QA process to make sure that, and Tori, you touched on this, but leverage the information that they do have and that they can get. Are there check to identify where there are areas, geographical areas, are there individuals, are there groups of individuals where they might have a lower than average response rate, or response rates that are much higher than similar groups within the financial institutions. So all things to be thinking about as we think about discouragement risk and you move towards implementation with the new rule. And maybe the last thing I'll say here, Frank, as it relates to your question, and as organizations do that current state assessment and understand, again, their people, the roles and responsibilities, the systems, which are key, especially if there's any third-party vendors involved there, which I know many institutions have, processes. I think one thing to keep in mind is try to, of course, be compliant with the rule, but also make this as easy as possible for your own team, as well as your customers. And this is going to be new for everyone. So keeping that in mind as well, to the extent possible, I think will be helpful. And as part of those conversations, I do think many are considering, is this an opportunity to digitize applications and make their and bring that into their processes? That certainly help on the back end as they are looking to aggregate and report this information. And then I guess that the last thing I would say is that many are considering or talking through is, do you begin to collect and capture data earlier than required? And one thing I think this would help you do is pressure test these processes. Is it working well for your team? Is it working well for your customers? And that allows you, if you are collecting early, to make any adjustments ahead of the compliance timelines as well.
Yeah, that's a great point, Kate. And maybe just following up on that thread a little bit more in talking about collecting the data early, what are some of the things that you're seeing in the industry around kind of how and when financial institutions should start thinking about capturing 1071 information from their customers?
Yeah, I think that's a great question, Tori. And I guess just to make sure everyone's on the same page, of course, organizations can collect 12 months before the respective compliance deadline. So for institutions with at least the now current October 24 implementation date, this means they can start to collect as early as October of 2023, which now that we're in September, that is next month. And I guess I will pause before continuing forward. Tori, Frank, are you aware of anyone who plans to start collecting as early as next month?
I'm not personally. I'm sure there's someone out there that's a real go-getter and is going to go for it on day one, but I haven't been working with anyone who's quite that far along just yet. Frank, I don't know about you.
No, it's the same with me, Tori. I personally haven't worked with anyone who's going to start collecting data that early.
And I agree with you both. I have not heard that anyone does plan to start as early as next month. And I think that it's just a good segue into what I think many of the clients are thinking through in terms of the benefits to collecting early versus maybe some potential drawbacks. So some of the benefits to collecting early, and I touched on this, it is a way for institutions to, again, pressure test those processes. Is there any kind of trending or things that you're seeing in terms of roles and responsibilities, or the systems you're using themselves, or the processes, the controls? Is there anything you're seeing as you start to collect that information early where you would want to make some tweaks or changes before the compliance deadline? And I think the other benefit that many are talking through is it does allow institutions to start their fair lending analysis early, helps them to understand the response rates that they are getting. Are they seeing any disparities amongst racial and gender groups as well as different geographical areas, perhaps? So I think those are the two that stand out in the conversations that I've been having in terms of benefits to collecting early. On the flip side, potential drawbacks, I think some are concerned that customers might have a hard time understanding why a financial institution is asking for this information in terms of the optional demographic information if it's not required for another year. Will they not understand that so much where they may want to go look for an alternative institution for their financing options? I think another big one is once the institutions have the data, there's an expectation that they act on it, which could be something that many are not fully prepared for, at least at this point in time. And then the last point here, I think similar to the three of us not being aware of anyone who does plan to start collecting as early as next month, is I do think there are concerns with some of being the first out of the gate, especially if they have concerns or don't know what to expect in terms of the story that their data is going to tell them, especially if there are thoughts that it may not be advantageous or positive.
Yeah, and I would just add one more potential drawback there, one more consideration, Kate, to that list that you helpfully outlined. I think the recent litigation that Frank summarized for us earlier adds a little bit of a wrinkle to the question of collecting data early. So for institutions that are subject to the preliminary injunction or trying to take advantage of that, can they still choose to collect early if they technically are not yet subject to the rule, or could that raise additional potential considerations about early collection? I mean, my personal inclination is that the CFPB would continue to be supportive of early adoption in these circumstances, although I think there is a little bit of ambiguity out there. So switching gears a little bit, we thought what we'd talk about for the balance of our time is drilling down into some of the frequently asked questions and update listeners on recent guidance released by the CFPB. At the end of June, the CFPB released a frequently asked questions document and webpage and hosted a webinar covering frequently asked questions that it's received to date from the industry about the small business data collection rule. From the FAQ document, which is available through the CFPB's 1071 page, there are a few areas that we wanted to highlight. First, in starting to implement this 1071 small business data collection rule, one of the questions that's come up pretty frequently is who needs to report a particular transaction, especially when there are multiple entities involved in the origination process. So at the most basic level, if there's only one financial institution involved in making the credit decision, then clearly that financial institution will be responsible for reporting the covered origination to the extent that they are a covered financial institution. However, where it gets a little bit trickier is if there's more than one financial institution involved in making a credit decision. The general rule under 1071 is if more than one lender is involved in making the credit decision, then only the last lender with authority to set the transaction's material terms is required to report the resulting covered origination. And the rule is intending to reduce duplicative entries so that there is essentially hopefully one institution that reports for each covered origination. The last financial institution with authority to set the material term under that general rule is the one that's required to report the covered origination. And that's even if it does not exercise that authority. So under the rule, setting the material terms of credit can include, among other activities, selecting among competing offers, modifying pricing, modifying loan amount, or modifying repayment period. And those are just a few examples that are given under the rule. The final rule and the small entity compliance guide and the FAQs that the CFPB released in late June all provide some helpful illustrative examples of which entity is responsible for reporting a covered credit transaction in certain circumstances. So lenders should review these examples carefully and evaluate their own specific facts and circumstances. But the determination of who is required to report an application can be very nuanced when you have a number of different entities that are playing different roles in the transaction, including situations where you have dealers or brokers that are working with multiple lenders to obtain financing. So lenders should think about considering their individualized circumstances and who has the authority to set the material terms of credit, including whether anyone has the authority to select among competing offers. And that's even if that authority is not routinely exercised. This may involve a review of contractual provisions. This may involve a review of actual practices. And when you're thinking about or undertaking this analysis to determine whether you as a lender are the entity that's required to report a particular type of transaction, or whether another financial institution will report, consider documenting your rationale so that if you're ever asked to justify your decision, either to the CFPB or otherwise, you have a good contemporaneous record supporting the conclusion of whether to report or not report certain types of transactions if there's some ambiguity. Another question that's come up a lot and is addressed by the CFPB's most recent set of FAQs is whether startup businesses are considered small businesses for the purposes of the 1071 data collection rule. Generally, the answer is yes, and that's articulated in the CFPB's most recent FAQs. If there's a new or recently started business that did not operate in the preceding fiscal year and therefore didn't have any gross annual revenue for the preceding year, and it also does not have any affiliates with gross annual revenues exceeding that $5 million threshold, the new or recently started business will be considered a small business for the purposes of 1071. However, the CFPB has advised financial institutions to look at the SBA's regulations for guidance. And under the SBA's regulations, a business is not treated as a separate business if a substantial portion of its assets or liabilities are the same of those as a predecessor entity. In that particular circumstance, under the SBA's regs, the annual receipts of the predecessor business can be taken into account in determining gross annual revenue, and therefore may result in a determination that a new or recently started business is not a small business. What's important from an implementation perspective is that when determining whether a business is a small business, and therefore whether 1071 data collection is implicated, a financial institution can rely on an applicant's representations regarding gross annual revenue, unless the institution is actually verifying the gross annual revenue. A financial institution is permitted, but not required, to aggregate an applicant's gross annual revenue with its affiliates' gross annual revenue. As a result, if there's a new business and it states that it and its affiliates' combined gross annual revenue exceeds that $5 million mark, and the financial institution doesn't verify gross annual revenue, then the business is not a small business and the lender doesn't need to collect the information required by 1071. However, if the financial institution does update gross annual revenue information or verify gross annual revenue information, it must determine whether the business is a small business based on that updated or verified information. Another question that's related to the topic of whether or not an entity is a small business and whether or not it's a startup business is whether or not special purpose entities or SPEs are small businesses for the purposes of the 1071 data collection rule. With regard to this question, the answer is a little bit trickier in that it depends. It's essentially the same analysis as I described for startups in that it depends on the SPE's reported gross annual revenue, which may or may not include affiliates' gross annual revenue and whether that exceeds $5 million. Again, as a general matter, a financial institution can rely on an applicant's representations regarding an institution's gross annual revenue. One final topic that we wanted to touch on very briefly, because it's coming up a lot for our clients, is the reuse of data. The rule generally provides that certain data points can be reused without confirming accuracy with applicants for up to 36 months. So for example, a financial institution can use previously collected data around industry code, around number of workers, time in business, minority or women-owned business status, the number of principal owners, etc. This permissible reuse of information for 36 months is subject to the additional caveat that reuse of data is only permissible so long as there's no reason to believe that the data are inaccurate. So for example, if the financial institution knows that there's been an ownership change, then it may need to reconfirm the validity of ownership related information, even if it's been less than 36 months. Also, gross annual revenue can be reused if it is for another application in the same calendar year. This generally makes sense because by definition, gross annual revenue will necessarily change year over year, but it can only be reused for a shorter period of time. Are there ways that financial institutions can make the application process more streamlined, even if more than 36 months has passed? In the preamble to the final rule, the CFPB states that even outside of that 36-month window, institutions can use what they call reasonable procedures to reaffirm data that was previously collected. The CFPB states that the rule does not prevent lenders from identifying efficient ways to gather 1071 data, which can include leveraging previous 1071 data to streamline the process. This would include circumstances in which the financial institution pre-populates the data on an application, for example, and the applicant has the ability to change or reaffirm their responses. The CFPB's preamble to the final rule also suggests that financial institutions have some flexibility in developing procedures for the efficient collection of data, but lenders should take into consideration things like the amount of time that's passed, the likelihood that the data is stale, and should really develop procedures that are appropriate under those specific circumstances. So with that, I think we're out of time. There's likely to be more to come on the 1071 rule in the coming months, so definitely stay tuned. And we may have to invite Kate back for another update.
I'd love to.
All right. Well, thank you, Tori and Kate, and thank you to our audience for listening. Listeners, if you have any questions about today's podcast or anything else related to global financial markets, please email us at gfm@mayorbrown.com. Thank you very much for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.